This is the second part of the August 20th, 2013 Austin Constitution Meetup. I'm Jon Roland. In this segment, we'll be discussing the problem of eminent domain as applied to personal property. This has come up in a recent case in the state of California, where the city of Richmond has sued to try to take, using its eminent domain powers, a number of mortgages on homes. Not the land on which the homes are built, but the mortgages on that land. And their stated purpose is to be able to get control of the mortgages and thereby either renegotiate them downward to match the market value of the property. Many of them are underwater, or even to perhaps foreclose on them and take the houses and sell them to somebody else. But there's a problem with that. Of course, now the banks, the lenders, are objecting to that. They're suing for declaratory and injunctive relief to prevent the city of Richmond from doing that. Of course, from their point of view, it's simply taking their property and probably not paying full value for it. So the problem with that is to examine what it is that a mortgage is and whether or not the power of eminent domain applies to it. Now, the original concept of real property, that is to say land, was that all land was owned by the sovereign, which in medieval times was the monarch. When the United States separated from Britain and became a republic, the monarch was replaced as sovereign by the people collectively. But if the principle remained true that in almost every country, the underlying land is not primarily owned by individual or private parties, it's owned by the people. And what individuals or private parties can own are claims on the land, which are sometimes called estates. An estate is a bundle of rights. It's a right to exclusive possession, use, disposal, inheritance, conveyance, subdivision, and so forth. So a large bundle of rights that pertain to the land, but strictly speaking, those claims are not real estate. Those are, that is to say, they're not real property. They're personal property, because they can be moved around and exchanged, separated, divided, held by different parties. So they have the character of personal property. Now the question arises whether eminent domain is a power that can be applied to claims on land, or for that matter, on any other kind of personal property, and not just on the land itself. The U.S. Constitution does not use the term eminent domain, nor do most state constitutions. It talks about takings, generally. And there are more than one way that government can take property. Eminent domain is one of them. The most common situation in the early republic was simply armies on the in the field taking food and provisions that they might find in farms, and perhaps giving the farmer an IOU, but which was supposed to be paid by the government, but expropriating the property for use by the military operations, living off the land, as it were. That is a kind of taking also, and it is covered by the Fifth Amendment to the Constitution, but it is not the exercise of an eminent domain power. These are two different powers. In fact, the takings in the field of battle would really be more a matter of a wartime power than of eminent domain power. So, we had an interesting turn of events, though. Up until the 1876 case of Cole, the United States, it was presumed that only the states were sovereign over their land, and that if the United States, let's say the Union government, wanted to take land, they had to get the consent of the state legislature, and they had to go through state courts under the state's eminent domain powers in order to get that land. They couldn't do it directly. What the Cole decision did is it sustained a claim or a practice by the U.S. government to take it directly. And if you recall in the Constitution, it provides in Article 1, Section 8, Clause 16, that the United States may accept parcels of land with the consent of the state legislature for purposes of a national capital and for various other purposes like forts, dockyards, and so forth. But those all had to require the consent of the state legislature. They couldn't just be taken directly. The problem is that although the Union government did have sovereign ownership of land in the territories, it did not have in the original 13 states, and it did not have in the territories when they were organized as states. When a territory is organized as a state and admitted into the Union on an equal basis with other states, the state thus created now has ultimate ownership of the land in that state. Even though the Union government might retain a fee simple title in some part of the land in the state, as they do with large parcels in Nevada and other western states, the simple fact is that that's still ultimately state land under state legislative jurisdiction. So the defining characteristic of ownership is legislative jurisdiction. In other words, if a lawmaker can make laws for a territory, it is the ultimate owner of that territory, regardless of what ownership in the form of estates that private parties may have. Now, the question arises now, is there an ultimate ownership of the same kind in personal property? Now, a common argument for the imposition of property taxes on personal property is that the state is also the ultimate owner of personal property. However, that is not borne out by the historical legacy of our legal system. Many states have enacted personal property taxes on tangible commodities, but not on intangible commodities. Thus, they aren't intangible personal property. The theory, when it's been challenged, is that tangible commodities are somehow derived from the soil and therefore carry with them some of the attributes of ownership by the sovereign. However, that's not true of all tangible commodities. They are not all derived from the soil, at least not from U.S. soil. They might come from outside the United States. So if they come from outside the United States, they are not, strictly speaking, derived from U.S. soil. Now, clearly, a mortgage, being a claim on real property to secure payment of a note, is an intangible form of intangible personal property. And to seize it will take something more than the power of eminent domain. Now, such property can be redistributed through civil litigation, where the government plays the role of mediator in disputes as to who is the real owner of things. But that is not the same thing as taking it, because it already owns it and is simply extinguishing the claims to possession and use of it. So my argument in this paper, an article on constitution.org, which can be found under Rights, Powers, and Duties, and you scroll down, you'll find the title Dubious Domain. I'm sorry, you'll find property and privileges, and then in the page on property and privileges, property and privacy, you will find a link to the article. I combined property and privacy into one page, one gateway page, because the two are very closely linked. Generally speaking, one has privacy in one's property, and although it is not always made clear, the two are so closely linked that it makes sense to combine them in that way. So I contend that the Cole case was wrongly decided, and that a state, when it is created out of territory over which the United States did not have sovereign ownership of personal property, does not thereby acquire that kind of sovereign ownership. Now, one could argue that the people of the state, when they enact a constitution, as is alleged that California has done, could provide the state with the authority to take personal property by eminent domain. However, there is some question about whether the people of a state even have the authority to delegate that power to a state constitution. And that's what I argue against in my article. That is not a power that is theirs to delegate, and therefore it is unconstitutional to take it through eminent domain. There may be other bases for taking it, or more of a regulatory or tax power basis, but not through eminent domain.